Michigan schools are rethinking student discipline. Before 2017, zero-tolerance policies resulted in widespread suspension and expulsions, removing students from the classroom and increasing their academic risk. Michigan law now mandates expulsion only for dangerous weapons, arson, or criminal sexual conduct in school. For other issues, schools must use restorative practices, focusing on responsibility, repairing harm, and rebuilding relationships. The law prefers these restorative practices for interpersonal conflicts, bullying, fights, theft, property damage, classroom disruptions, harassment, and cyberbullying. Despite reforms, statewide data show disturbing disparities in discipline. Last year, Black students, just 18% of Michigan's 1.4 million students, accounted for approximately 43% of expulsions, while white students, who make up 62% of state enrollment, represented only 37%. And school discipline practices that remove students from their regular classroom or school setting, like suspensions or expulsions, remain disproportionately high for students with disabilities. To better understand these issues, today we'll talk with experts who will explain how Michigan schools are balancing safety, fairness, and opportunity as they move away from exclusionary discipline and help families understand their rights to better protect their children. We'll be right back. Welcome back to Legally Speaking. I'm Ashley Lowe, the Chief Executive Officer at Lakeshore Legal Aid. We're a nonprofit law firm that provides free civil legal services to people living with low incomes, older adults, and survivors of domestic violence and sexual assault throughout the state of Michigan. Today on Legally Speaking, we're going to talk about the important work that's being done to keep kids in school or return them to school. Our first guest is Jenna Pickman. Jenna is an education advocate at the Student Advocacy Center of Michigan, where she's worked since 2018, or as an intern a couple of years before that. She has a master's in social work from the University of Michigan, where she focuses on children, youth, and families, and has a certificate in school social work. Jenna, thanks so much for being here today.
Thank you for having me.
Thanks. And our next guest is Susan Marquardt. Susan is a supervising attorney at Lakeshore's Counsel and Advocacy law line, where she has worked for 17 years, and she advises clients across the state on issues such as family law, housing, consumer protection, public benefits, and of course, education. Susan has been a leader in Lakeshore's efforts to help clients facing expulsion and suspension. She's a mother of 3 and is a committed advocate for special education and for animal rights. Susan, thanks for being here.
Thank you.
All right, Jenna, let's get started with you in the Student Advocacy Center. Can you tell me about the organization, what you do, and your mission?
Yeah, absolutely. So the Student Advocacy Center is a nonprofit that focuses primarily on special education, students with disabilities, school discipline, keeping students in school, and helping parents, caregivers, guardians understand their legal rights when it comes to school. And specifically in our Ed Advocacy program that I'm a part of, we advocate for students to keep them in school, realize their rights to a quality public education, really amplifying student voice and parent voice in their education journey.
So are your advocates working with students in schools and participating with them in school disciplinary proceedings, or in other ways?
Yes, absolutely. So we have a statewide helpline that supports students across the state of Michigan, K through 12 public education, providing support over the phone, virtually through email. And then we have our advocates in Wayne, Washtenaw, and Jackson, providing direct advocacy in those school discipline and special education meetings.
Got it. Okay. So let's talk about the disciplinary legal landscape. Can you tell me about zero tolerance and what that meant in the education context?
Yeah. So zero tolerance is exactly what it sounds like, and zero tolerance for any type of misbehavior. And the goal of the 2017 Rethink Discipline Law was to end zero tolerance. I can't say that that has been as successful as we would have hoped, but SAC really played a pivotal role in getting that legislation passed. We had youth from our Youth Action Michigan organizing up at the state, speaking with legislators, doing action up there, having a march up to the Capitol to try to advocate for that change, to do away with harsh discipline and long-term removals for just any type of behavior.
So was that the issue, that it just was more harsh than it needed to be in a lot of circumstances?
Yes,
and
absolutely.
that impacts certain segments of the population?
Yes, so, and we still see it today, that there's a disproportionality of removal for students of color and students with disabilities, and students who fall in both of those identity categories. It's twice as harsh for them.
And so under the new law, what was the reform? What was the main reform that happened?
Yeah. The goal obviously was to end zero tolerance, but the purpose behind that was to look at students individually and to consider 7 factors about a student. So their age, their disability status if they have one, their discipline history, the severity of what took place. Another piece of the bill package was to consider restorative practices. And to look at restorative practices specifically for interpersonal, verbal, and physical conflicts between students.
So what do you mean by restorative practices? What does that look like, and how does it play out?
Yeah, so restorative practices are really a continuum of informal to formal supports. And so informal can be as small as asking restorative questions, like what happened, who was harmed, how can you repair that harm? And the more formal is voluntary conferences between victim and offender to try to repair the harm that was done. So maybe it's a fight between 2 students and they sit down with someone who's restorative trained and they talk about what happened and how it harmed the victim, and the offender, what can you do to repair that harm, versus removing a child from school.
Got it, got it. And so you mentioned that it's not working perfectly. What are some of the concerns that you're still seeing?
Yeah, I think the biggest thing is that in the state of Michigan, when it comes to pretty much any education law, it's local control. So districts kind of have at their will to do what they want with that. We see districts that implement it beautifully and do the 7 factors, and they put it on paper and in writing, and they really do what the law intended. And then we see other districts that just dismiss the 7 factors and don't even bother to do it, or they just check the boxes and they don't really consider that child on an individual basis.
What's the accountability for that for school districts? Is there any?
To be honest, there isn't any accountability. That's the biggest problem with that law. There's no teeth.
Talk a little bit about the high number of suspensions, that disproportionality for students of color or students with disability. Why is that going on? What causes that?
I think one of the biggest things is lack of training and implicit bias of our educators. Our teachers are overworked, underpaid, but they're also not receiving proper training to do the work. A lot of schools where the student body and how they look is not reflected in the staff, there's a lot of bias in there. There's a lot of lack of training of how to support those students.
So when you're seeing discipline for students of color or students with disability, what are the types of categories that they're being disciplined for? What kinds of things are you seeing?
I mean, the types of discipline that we see for students of color or students with disabilities is the same type that you would see for their white counterparts, but sometimes their infraction is harsher, or their consequence actually is harsher. Okay. But it's things as small as insubordination, not following instructions. We see persistent disobedience a lot, which is super subjective because it's taking all of your previous infractions and saying you continue to repeat the same problem, so let's just tack on an additional consequence for repeating the same issue.
Got it. So just even though it's just one situation, they're building upon a long history.
Yes, exactly.
Got it. All right, thanks, Jenna. Yeah. Susan, I want to talk a little bit about Lakeshore and the work that you're doing at the organization and how Lakeshore helps support families in these circumstances. Can you talk about that?
Yeah, sure. So I work in the Counsel and Advocacy law line, and we are a hotline legal service provider that's part of Lakeshore Legal Aid. I like to describe our part of the organization as the emergency room of legal services. We have a hotline that is accessible to people throughout the state of Michigan, and they call in on it. We have regular business hours, and when they call in, we start by determining if they qualify for our services. We are a nonprofit agency, so there's some eligibility issues we need to just get through. Then we get background on what their matter's about. It's not at all uncommon for education law issues to sometimes come in through a back door. The call might come in as an eviction case or family case, a dispute over custody, where it comes out when we are doing our fact finding and issue spotting that there's some kind of undercurrent of education matter, maybe a discipline issue that led to a single parent having to come home all the time, and then they lose their job, and then they don't have money to pay their rent. So that part is very important. And then from there, we try to provide tailored legal advice to their specific matter, hopefully giving them the resources they need to decide what to do. Does their student have rights that are being violated? Does the school have obligations that are being ignored? And then sometimes we're able to refer files over to our local litigation office at Lakeshore, where we have litigation attorneys that we sometimes are able to partner with our clients to potentially go into an administrative hearing with them, or maybe meet with the school and work through issues, negotiate some kind of resolution. And then last piece of our work is that we are really focused on making sure our clients are connected with other resources like the Student Activity Center in terms of support resources out there, because there are some very good ones in the area for people to use.
So kind of a holistic approach to, like, here's your rights, here's how you might be able to advocate for yourself, and here's other supports.
Yes, 100%, 100%.
Yeah. So from a legal standpoint, what does that disciplinary process look like? What's that entail?
Well, there's different types of discipline, and they each come with their own rights and obligations, I guess, on the other end. Probably the most commonly thought of is maybe just when detention. There's a lot of TV shows, kid TV shows, movies, The Breakfast Club, that talked about detention, and that's just a temporary removal during non-core academic hours. There's not a lot to say about that. That's something that's been around for a long time, and there's not much that comes with that in terms of legal rights. But those things are laid out usually in a school's code of conduct. The most common type of discipline that we end up talking to folks about is suspension. That's where they're actually being removed from an academic setting during core learning hours. They're missing out on learning. Suspensions today can be both in school and out of school. So sometimes a child may not be picked up, but is basically missing class time by sitting in an administrator's office. The most severe would be expulsion, where they're removed from the school on a potentially permanently, but not always. Although kids who face expulsion can sometimes, if they're fortunate enough to have a district that offers alternative education school, they can sometimes enroll there. There's also...
If there's been an expulsion, they can go to the alternate...
Yes, yep.
Okay.
That's one last resort option for kids that are being expelled. And then sometimes there are discipline, like a boot camp kind of setting for certain kids as well. The other
kind, you mentioned that there, like in the detention setting, there's really not many rights that just go to detention and experience it. Mm-hmm. But in the expulsion and suspension, what are the rights that students and families have?
Yeah, good question. So first of all, there's a due process right to notice of what you're being accused of. What are the allegations against you? You're entitled to a right to challenge those allegations. If you disagree with the allegations, you're entitled to have access to the information that's being used against you. Notice doesn't have to be in writing, but it often is. Notice doesn't have to be immediate. It can be under certain circumstances after the child's already been removed from the school setting. If the school believes there's some risk to a person or to property, they can remove the child, then give notice. They can also do that if they believe there's some kind of interference in the academic process.
So they get notice, and then is there a right to have a lawyer in those proceedings?
Yes, you could seek legal counsel to help you with that process. I should mention too, one thing I forgot to mention is that the notice should specify what type of discipline is being imparted and the duration. And we do get calls from folks all the time where that's not specified, which is sometimes surprising.
That they're seeking suspension versus expulsion or detention. That's not part of the notice.
Yeah, and it's not specified for how long. And that's important because there are certain rights that come into play when discipline or suspension goes beyond 10 days, as Jenna was talking about a little bit earlier, and even more so for children that receive special education support services.
So let's talk about that in terms of students' disabilities and what special rights do students with disabilities have?
Yeah, that's a great question. There are some good protections in place there that do help some. For kids that that have something called an individualized education plan or program, that's a document that they receive, they have to be qualified for, they have to seek, there's a whole process in getting an IEP in place. But once they have that, it lists tailored accommodations, or it's supposed to be tailored accommodations to help support the child based on their disability. All children have a right to a free and appropriate education. So this is supposed to help lift up the child in reasonable ways to be able to achieve their best at school. If the child has an IEP in place and they're being suspended beyond 10 days, the school is supposed to hold something called a manifestation determination review hearing, where they take a look at the child's behavior that was in question and whether it's tied to their disability. And they also look at the accommodations that the child receives in their IEP, and the school has to show that they fully upheld those accommodations.
Yeah, so tell me a little bit more about that process. If there is a determination that it was their disability that really was a part of what happened with the behavior, then what kind of protections fall into place?
Well, they shouldn't be proceeding with a suspension if that's the case. If the school chooses to proceed with the suspension, then there's then that's kind of where the escalation comes into play in terms of how to challenge it. It might be filing a complaint with an intermediate school district if it's more of a general grievance, but usually when it involves IEPs and whether accommodations are being supported, it would be a complaint to the Michigan Department Office of Civil Rights, where they have an obligation to investigate those types of complaints. You have to bring a complaint with them within 1 year of the allegation. They have to investigate and make a decision within 60 days.
So there's a higher level of review if students are, if it's for students with disability and they feel like their rights are not being protected.
Yes, 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 absolutely.
Okay.
Yep.
And you mentioned IEP, which is individualized education plan, and I've also heard about 504 plans. How are those two different?
Yeah, good question. There's a lot of confusion around what that means, but they're both, I guess, at their core, they're both mandated under federal law, and they both provide for supports for children with disabilities. 504 plans, I think the plus that sometimes is put out there for people is that it addresses a broader scope of disabilities, but I also think there's sometimes misinformation or misunderstanding of how broad an IEP eligibility can be, because IEPs do address a pretty broad range of disabilities. IEPs, from my perspective as a legal aid advocate, helping families with education issues is a little bit, it has a lot more protection in place for a child. It's a much more very specific document. 504 plans don't even have to be in writing necessarily, although they often are. IEPs are also, when putting together an IEP or a 504 plan, a parent is not or a caregiver is not a mandatory part of that process, where under the IDEA, which is the federal law that mandates IEPs, for children that meet the requirements, a caregiver is a part of the team, a really important part of the team. But I think the specificity of an IEP is super important from a discipline standpoint. It really helps to show exactly what a school should be doing to support that child before they're being disciplined.
And then you can identify if they aren't doing that, right?
Yes.
Then that's where the protection lies.
Yes.
Right. So
exactly.
We've talked about expulsions and that the idea is restorative practices, but there are certain circumstances where expulsions are required. And in those situations, what happens? Is there an opportunity for kids to get back in school?
Yeah, that's a good question. So reinstatement is what you're describing. There is a process for children that have been expelled to seek reinstatement. When a child is expelled, it's for a minimum of 180 days. But if they're interested in re-entering the school system or the school that they were in originally, they can apply for reinstatement at 150 days out from the expulsion. Yeah, so it's a lengthy period of time. And expulsion is from all schools, all public schools in the state. It's not just the school that they were attending. So
they can't just go to another school, or they can't move to another school district and accommodate that.
Yes.
Right. But you mentioned there are other placements, right? That there are other places. There might be other schools that can accommodate kids who have been expelled.
In some cases, probably not so much in more rural settings, but in some school districts have alternative schools where they are specialized in helping kids that are kind of going through some of these extreme difficulties in school where they've been expelled.
Okay. And so when you're talking about the services Lakeshore provides and referrals for representation, where does Lakeshore fall into those cases? When might we send a lawyer to go assist a family that's in these proceedings?
Yeah, so in terms of where do we fit in, I guess first I would say in terms of when to call, I would say there's no time too early to call if you're heading down a path of trouble where you're concerned about things going in a wrong direction. And our part of the part of organization I work in, the Counsel and Advocacy Law Line, can field those types of questions. But in terms of a physical person going with them, our litigation attorneys might get involved in meeting with a school. That if a child's going through discipline and there's some concerns about their accommodations being properly upheld, our litigation attorney might meet with the family and the school to look at that. Maybe the IEP needs to be written a little bit more tightly to really clarify exactly what those accommodations should be, to make sure the school understands what their obligations are. Sometimes it is just lack of understanding on the school's part. It's not always nefarious and them intending to cause trouble.
But maybe, like Jenna said, a little bit of lack of training in what they're doing.
I totally agree with that, yes.
Yeah.
Yep.
Yeah, and so what's working? You've talked about, Jenna, you've talked about some challenges that you face, but what are the things that are really working in this new kind of legal landscape?
I think it depends on the district. I think the districts that are really taking the time to do the training, both on the 7 factors, the rethink discipline law, restorative practices, taking that time to understand the purpose of that law and why it was implemented and doing the work, improving their school culture and climate, things like that, that's where it's going well. It's the districts that, either don't have the resources, the funding, the staff, the time to do those kind of things, that it's a struggle, that we're not seeing improvements. One thing I forgot to mention that we see quite often is schools kind of finding a loophole out of that expulsion situation where you have that due process right to a hearing and the evidence against you, and instead of going that route, they just put you in virtual school. And we've seen an increase in that, a huge increase in that since COVID, because COVID is when students all learned virtually, right? So they've used that as kind of a loophole of a way out. And for general education students, they don't have any protections or rights to get out of that situation. When it comes to a student with a 504 plan or an IEP, there are a little more protections in looking at their specific accommodations and whether or not that's the right place for them. Mm-hmm. But I just wanted to mention that virtual school is what we're seeing a lot of.
That's really interesting. So would it have started as a suspension or expulsion type hearing, and then the answer is let's assign you to virtual school, or what's the path?
I've seen both. I've seen situations where they're suspended for a couple days and then a parent gets a phone call from a principal or an administrator saying, hey, we're just going to move your student into virtual school. And the parent's like, whoa. And they don't really know what they can or can't do in that situation to get them out of it. Or I've seen it goes as far as an expulsion hearing. They go in front of the school board or a panel from the school district, and their decision is to put the child in virtual school. So it goes both ways.
And that could just be for the rest of the school year or longer?
I think what you were mentioning earlier about putting it in writing and the number of days, I've seen the virtual school last a semester, a whole school year. I've also seen it been put in writing that it's indefinite for that child's rest of their K through 12 education.
Yeah. Wow. Well, let's talk about some of the good things that are happening. Jenna, tell us about when things work out and you're able to do a job and people have reached out to you. Give us some success stories.
Yeah, absolutely. I'm thinking of one in particular that I just had last school year. It was a 3rd grade 9-year-old boy. He came to the Student Advocacy Center with tons of suspensions, left and right, repeated behaviors, back and forth, constantly being sent home from school. But when I got involved, I was able to kind of bridge that gap between the parent and the school district and the administrators and really open up that line of communication that wasn't really open to begin with. The parent kept asking for help and they were being ignored by school. And my role is always to be collaborative. We're not adversarial. We're non-legal advocates. Mm-hmm. Obviously, we get legal advocates involved when we need to. But in this particular instance, me being involved helped open those doors. The student got an IEP. He also got a behavior intervention plan to support him. And by getting those accommodations and those supports, his behaviors went down and his attendance and his grades went up. And so those type of situations are what we see quite often. But, it kind of depends. It's a case-by-case basis.
So really just opening up that communication and helping the parents kind of find their voice in their discussions with the school.
Absolutely. Yeah, our role is to empower parents and caregivers and guardians to be the best advocates for their children. Yeah, we work alongside them, never for them.
And Susan, how about you? How about some examples of when there's been able to be legal intervention that you've had a success?
Yeah, one that comes to mind is a child that came to us. They were at the time, 8 years old in 2nd grade, and they had been suspended 30 times in the first half of the school year, which is a lot for a 2nd grader. And we did get permission from the parent to share a little bit about this, but I don't want to get too personal with the information. But these weren't shocking, dramatic things that were going on. They were what a 2nd grader getting into trouble might do. But obviously having a significant impact on this child's experience at school and high risk of being held back. It was really, really not a good situation. So we advised him at the Counsel and Advocacy Law Line. We were able to get him connected with one of our litigation attorneys through Lakeshore Legal Aid. And the attorney did an excellent job. They met with the school on 2 different occasions and had their IEP tightened up. So that it was extremely clear and explicit what the school should have been doing all along to support the child before even considering discipline. Because I think what had been happening is there was really very little effort to uphold the accommodations, and instead they would just send the child home and suspend him. The attorney took it even further, was able to get the school to agree to put the child into one of their magnet schools that was better, it had better support resources in place for this child in terms of their disabilities. And then the icing on the cake was they got the child into a really high demand summer program that was difficult to get into, and this child really benefited from it and had things turned around for that child.
Wow, so that's a lot of layers there of the interventions, right? So thinking about tightening up that IEP, I know when I look at the cases that we do, that seems to be one of the biggest places where we can have, and all of us, right, can have that impact, is making clear to the school that this is the accommodations that are necessary, and you have to do that first. Right, and lifting that up. And I think when folks maybe try to handle this on their own, they don't always get that really clear language around what the supports need to be in place.
Absolutely, absolutely. Yeah, there's unfortunately we see a lot of cookie cutter IEPs where the accommodations are very broad in general. They're not tailored. And that really is a disservice to the child. And it makes it harder for the educators too, because they don't know what they're supposed to be doing. It really doesn't serve a lot of purpose other than to make it a little less easy for us to hold them accountable.
Right. And we know educators are probably trying to do their best to help
absolutely.
The kids. And
the
so
teachers care, they want to do the right thing.
Right. I think when there's that legal process and people sometimes freeze, and while they may be coming from a good place, they end up kind of stumbling because they don't want to get into legal hot water. And so maybe having advocates come in rather than lawyers in certain circumstances might be the answer.
Definitely. I mean, not gonna lie, people are also afraid of advocates too. But, I've had my fair share of schools be a little nervous when they hear the word advocate. But I think sometimes it does help that we are non-legal, and our goal is to collaborate. And when they hear lawyer, they think, oh, we've got to get our district attorney, we've got to pay for our district attorney, they're going to file a lawsuit, they're going to file a complaint. So yeah, it kind of depends on the circumstance.
So let's talk about how we can let people know where they can go if there are issues. So what should people do if they have a child who's struggling in school, who's having disciplinary issues? What's the first step they should take?
Yeah, I think the biggest thing is writing everything down. Take notes for yourself, ask for documentation of paperwork, send follow-up emails reiterating the phone calls that you received. Ask for everything in writing. But when you're being met with those adversarial situations, you're not getting your needs met, your voice isn't being heard, call our statewide helpline. We're always there to answer questions, provide support over the phone.
And Susan, how about for Lakeshore?
Well, I would say they can call into our hotline for legal guidance, and through our 800 number, they can also apply to be considered for our services through Michigan Legal Help for an online application. I always tell clients, look at the school's code of conduct as a starting point. The school code of conduct lays out the rules, and it's not uncommon for schools to not always follow their own rules. So it's a really good place to start. It's kind of basic. I totally agree with Jenna's comments about putting things in writing. And try to remember that you are trying to have this tone of collaboration. You don't want to be, threatening, but just, here's the things that we talked about, and documenting that when you have a follow-up to a meeting. And I would say also just remember, you're attached to a school district for 13 years for your children. So you want to try and maintain that as much collegiality and spirit of working together as best you can.
Got it. Well, this has been really, really helpful. Jenna and Susan, thank you so much for coming and sharing this information. I think there's a lot of people who are dealing with these issues, and I hope this will help people find the resources that they need. So thanks so much, and thanks for joining us on Legally Speaking.